I'm Ben Meiselas from the MeidasTouch network. I want to share with you how federal Judge Aileen Cannon's judicial malpractice has allowed Donald Trump to feign prejudice in connection with special counsel Jack Smith's prosecution in the Southern District of Florida case for Trump's willful retention of national defense information, other classified information, other charges as well for making false statements and obstruction of justice. And now Donald Trump is trying to seek a delay, saying that he doesn't have access to all of these documents, and the real issue here is Judge Aileen Cannon's malpractice and Donald Trump's attempt to try to delay everything. Special counsel Jack Smith did everything right. So let's talk about some dates for a second. The indictment of Donald Trump in connection with the Mar-a-Lago document case was June 8th. It's when the indictment was unsealed. There was later a superseding indictment. But from the very outset, because this case involved classified information, it was going to be governed under not just the federal rules of criminal procedure, but also the law known as CIPA, the Classified Information Procedures Act, which governs how cases that involve classified information are handled. There has to be, in addition to a regular protective order that's often entered in cases that govern how documents are handled, who can see the documents, how they are filed, a separate special protective order in CIPA cases, Classified Information Protection Act cases, CIPA Section 3 protective orders. And this CIPA Section 3 protective order addresses how these documents are handled, where they are viewed. They're viewed in SCIFs, sensitive compartmented information facilities, how the documents are filed under seal, how they are transmitted to the judge. In CIPA cases, there are classified information security officers who almost serve as like special masters or independent monitors, kind of, and they work with the parties to handle these documents because they are so sensitive. So there's a whole set of rules how these documents are exchanged. For example, in a CIPA case, the parties can't review these documents outside of SCIFs, sensitive compartmented information facilities. And then there are limitations regarding what the defendant, who likely engaged in criminal conduct relating to these classified documents, can look at, how they can look at it. Can they take photographs of it? No, they can't. Can they take handwritten notes on it? It depends. Who can they talk about it with? Nobody other than their lawyers. So it governs all of the rules like that. We want to handle sensitive classified information in a sensitive way. So Jack Smith, from the outset of this case, was like, Judge Cannon, we need to enter a CIPA protective order right away. And Jack Smith submitted this right away. And Judge Aileen Cannon would she would strike the documents that Jack Smith was filing under seal. Also, when Donald Trump's lawyers entered appearances, they didn't fill out the paperwork because they have to get a limited security clearance for the case. It took them time to get their security clearance. And then Judge Aileen Cannon, she just sat on the CIPA protective orders. She didn't control her docket the way Judge Aileen Cannon, the federal judge of the other Donald Trump case, federal case in Washington, D.C. for his attempt to overthrow the 2020 election. Judge Chutkan handles her court efficiently, promptly, and moves it along. But see, Judge Cannon's never handled a CIPA case, Classified Information Protection Act case, in her life, and she doesn't seek help. As I always say, her corruption is matched by her lack of intellectual curiosity and incompetence. So she just sat on the CIPA protective order, didn't enter it, and then she made a mistake. Well, she didn't know what she's doing. So she set a public CIPA hearing on the protective order for August 25th. Right. And then she realized, oops, I made a mistake. You can't do CIPA hearings in public. Like, it's so basic that you can't do that. So then she issued an order saying that there will be no hearing on August 25th, and she'll set a date to have a hearing to discuss the CIPA protective order. She eventually set the hearing date for the CIPA protective order to determine what to enter. Remember, this was all about Donald Trump wanted to build the SCIF at Mar-a-Lago so he can just go out and review the documents like down the hallway at the scene of the crime. Remember, that was rejected. But take a look here. Judge Aileen Cannon entered the CIPA Protective Order on September 13th. It took Judge Cannon until September 13th to issue the CIPA Protective Order and signed it. And even though she ruled in favor of what Jack Smith and the Department of Justice wanted, it went from June 8th, when the indictment was unsealed, to September 13th before the protective order was entered. Here, you see this document here. Look at the top. You can see on the docket, September 13th is when she signed the protective order.
Oh, hey, when did you get here? Let's take a quick break to talk about our next partner, Henson Shaving. Look, everyone knows how annoying cheap razors are. The cuts, the irritation, the frustration. And don't get me started with subscription razor services, the headaches that those can cause. That's why you gotta meet Henson Shaving. Henson Shaving is a family-owned aerospace parts manufacturer that has made parts for the ISS. That's the International Space Station and Mars rover, and now they're bringing precision engineering to your shaving experience. Razor blades, they're like diving boards. The longer the board, the more wobble, the more nicks, cuts, and scrapes. A bad shave, it isn't a blade problem. It's an extension problem. By using aerospace-grade CNC machines, Henson makes metal razors that extend just 0.0013 inches, which is less than the thickness of human hair. That means a secure and stable blade with a vibration-free shave. It gets better. The razor has built-in channels to evacuate hair and cream, which makes clogging virtually impossible. Seriously, Henson Shaving wants the best razor, not the best razor business. That means no plastic, no subscriptions, no proprietary blades, and no obsolescence. The Henson razor, it works with standard dual edge blades to give you that old school shave with the benefit of new school tech. Once you own the Henson razor, it's only about $3 to $5 per year to replace the blades. My first shave with the Henson razor was incredibly refreshing. The design is sleek and the durability is top notch. The Henson razor is truly much better than your run-of-the-mill quote-unquote traditional razor brand. And the affordability factor is absolutely game-changing. No more wasting your money on expensive blades. With Henson Shaving, you get a year of blades for just $5. Okay, so here's what you have to do. It's time to say no to subscriptions and yes to a razor that'll last you a lifetime. Visit hensonshaving.com/Meidas to pick the razor for you and use code Meidas and you'll get 2 years worth of blades free with your razor. Just make sure to add them to your cart. That's 100 free blades when you head to hensonshaving.com/Meidas and use code Meidas. And now, back to the video.
So then what has Donald Trump just filed? Because of Judge Aileen Cannon's malpractice and not knowing what to do and waiting, June, July, August, September, like 3 months on this. Now Donald Trump's like, we need a delay. I hadn't got the documents, and Trump tries to blame it on Jack Smith in this motion. And the motion is styled as Donald Trump's motion for a revised schedule, motion to compel, and CIPA 4 litigation. I'll explain what that means in a moment, but the key thing here is the revised schedule. And it talks about, it says how this motion arises from the unjust efforts by the special counsel's office to foist rushed CIPA litigation on the court, Trump and his co-defendants. Early in these proceedings, the office of special counsel Jack Smith boldly asserted that it had all discovery, was able to produce it, and was ready to go to trial. Twice, the office committed to promptly producing all witness statements, even if the statements would not be deemed discoverable. The current schedule for discovery litigation and CIPA Section 4 practice would only have been feasible if special counsel's office made good on those promises. Yet 2 months later, it has not done so, and there appears to be significant unresolved disputes regarding the appropriate scope of discovery that will require substantive briefing and judicial intervention. Therefore, the hurried and unprecedented approach by the office is no longer viable. Nevertheless, The special counsel's office has not backed away from its assertion on October 10, 2023. Pursuant to the current schedule, it will seek permission to withhold materials from Trump that are the subject of the office's discovery obligations. So you notice that Donald Trump's lawyer in the sentence I read before is saying that it's been 2 months and we haven't gotten certain documents. First off, you've gotten all of the documents. Second off, Judge Aileen Cannon first entered the protective order on September 13th. You are now writing this motion on September 22nd, so less than 10 days after the protective order was issued. And Jack Smith wanted that protective order to be issued back in June. And your lawyers didn't fill out the forms, and Judge Aileen Cannon did not sign the order, which she should have just signed right away, standard stuff. She should have signed it in June. She should have signed it by July 1st, the latest, if she knew what she was doing, but she did not know what she was doing. And here's the thing that Donald Trump is whining about also. It's such BS. He's whining about CIPA Section 4 issues. And just so you know what a Section 4 issue, it's in these classified document cases, the government can request on an ex parte basis, meaning just to the judge, instead of showing Donald Trump and his lawyers in the SCIF the classified document. Instead, if the judge approves it, if you can make a showing of good cause, like showing the criminal information, more information about the crime could result in more crimes being committed. With Section 4, it says that on an ex parte basis, you could kind of summarize the document and show in the SCIF the summary as opposed to the document. So it's not improperly withholding documents because Jack Smith isn't prepared to turn it over. What it seems to be happening is that Jack Smith is simply saying, and Jack Smith's team saying, we'll do the Section 4 summary and not the underlying document. But again, Donald Trump's trying to confuse the judge or appeal to a corrupt judge. You could pick which one it is or both. I think it's probably both, to say we're not getting the records we're supposed to be getting when they've gotten all of the documents and the protective order was just entered. Now, if Trump didn't get documents turned over, and this was entered into back in June, and we're not talking about Section 4 issues, but just witness statements in general, then that's a fair argument. But that's not what we're talking about. We're talking about Section 4 summations of classified documents to be reviewed in SCIFs. And we're also talking about a situation where Judge Cannon first signed the protective order on September 13th for the first time. So then you have Donald Trump provides a proposed modified schedule. That's what this is all about. So Donald Trump blames Jack Smith for a delay caused by Judge Cannon, then lies and says Jack Smith's withholding documents when Jack Smith isn't. But then he gets to the heart of what he's asking for, and he's asking for this elongated briefing schedule through January of 2024 just on the CIPA issue. And so although Trump's not requesting a delay of trial here, that's basically what he wants. He wants to delay this trial as long as possible. And all of that is set up by Judge Cannon not entering the protective order when she should have entered the CIPA protective order when Jack Smith promptly submitted it to her many months ago. So you see how her malpractice, her doing things like that kind of assists Trump. Now, ultimately, does this make me worried or concerned? Not really. Ultimately, if she screws up, Jack Smith, once there's an appealable order, is going to go to the 11th Circuit. And her delay has allowed, Judge Cannon's delay has allowed Judge Chutkan to fill the void, and the case against Donald Trump for trying to overthrow the 2020 election, that's going to be going in March of 2024. So there will be a trial and there will be justice that will be taking place soon. So I want you to know that. Hit subscribe. We're on our way to 2 million subscribers. Thanks to your support. Check us out at patreon.com/MeidasTouch as well. Have a great day.
Hey, Meidas Mighty. Love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.